Good evening. My name is Adam Krieger. I'm with Warren Township Youth and Family Services, and I want to welcome everybody to this evening's presentation. The workshop tonight is Understanding Special Education Law, Be an Informed and Active Partner in the IEP Process. This workshop is from 6:30 to 7:30 p.m. If you did not receive nobody received a copy. So if you look in the chat section, you will see a link to our website where you can then download this PowerPoint if you want a copy of it. So what will happen is when you get to our website, you'll see the informational section for this workshop, and just go ahead and download the PowerPoint if you wish to have it. This workshop is great for parents or anyone who works with children or youth in the school systems. And let me just say, we always are so appreciative of having our speaker, Neal Takiff. I couldn't even tell you when the first time was that we did this workshop. It was, literally over a decade ago at this point, I'm sure. My kids were actually little, I think, the first time we did this. And we've done it, with the exception of COVID, I think we've done it on a very consistent basis. For the remainder of this workshop, use the chat to share resources or thoughts, and use the Q&A for questions. So I'd like to now go ahead and present our speaker. Neal Takiff is a partner with the law firm Whitted Takiff LLC. Prior to joining the firm, he was attorney with Lake County Public Defender's Office and with Cook County Office of the Public Guardian. Mr. Takiff received his law degree from New York University of Law and earned a BA in political science and philosophy from Duke University. He is a frequent speaker in the area on special education law, school discipline, and mental health law. So with no further ado, I'd like to hand it over to our presenter. Thank you, Neal.
All right. Thank you, Adam. Always happy to be able to spend some time and speak to y'all about special education law. I do have the question and answers up, and so I will try to do my best to answer any questions that are put out there in the Q&A. I don't have the capacity to control any settings here, so if you just have a question, put it in. I will say that there's been a request about translation. There is no translator for this presentation, but Adam and I spoke prior to hopping on, and this is going to be recorded, so you will have the ability to use YouTube translation to have this translated. So I want to get going, but before I do, as Adam said, our firm practices primarily special education and mental health law. We mostly represent parents in that capacity. We have a couple school districts we also represent. If you want to find us, I put some contact information, including my email, as well as our social media contacts. We do push out a lot of information about special education law, so feel free to join or like or whatever it takes to get that information from any of the social media sites. When there are changes in the law, we're kind of letting folks know about that through social media. As far as starting out, one of the things that I often get questions on is what's the difference between a Section 504 plan and an IEP, and do you need to have a 504 plan before you get an IEP? And so 504 and an IEP actually come from two separate laws. So a 504 plan comes from Section 504 of the Rehabilitation Act of 1973. And IEPs come from another federal law called the Individuals with Disabilities Education Improvement Act. And they're very different, and let's talk about that. Section 504 plans are, in order to be eligible, you have to meet three criteria. A student has to have a mental or physical impairment. That impairment has to be substantially limited. And then limited in one or more major life activities. And this does include learning. So learning is a life activity. When you have a 504 plan, generally the purpose is to prohibit discrimination on the basis of disability from any school program or activities. Section 504 actually goes beyond schools. But for our purposes, we're going to talk about schools. And the purpose is to provide equal access and fairness in general education to students with disabilities. Generally, 504 plans are less formal than IEPs, and usually we're talking about modifications and accommodations. So we're talking about a 504 plan might allow a student with a vision impairment to sit close to the board or in a specific area. Students with ADHD might have preferential seating so they can sit near the teacher so they can pay attention better. Students with physical impairment might have a modification where they don't have to bring their books from one class to another, that there'll be a set of books already there for them, or maybe an extra set of books at home. You could get related services through a 504 plan. Related services are things like speech and occupational therapy and physical therapy, but oftentimes those are through IEPs as well. When we're talking about the Individuals with Disabilities Education Improvement Act, this is where we're talking about IEPs. And there's also three prongs to eligibility. The student has to have a disability. That disability has to adversely impact the student's educational performance, and that the disability has to require special education and related services to address those educational needs. So to go back to my question, do you have to have a 504 plan before you get an IEP? The answer is no. If you meet these eligibility criteria, you have a disability and it adversely impacts educational performance, and you require special ed services, you get an IEP. It doesn't matter whether you had a 504 plan or not previously, and there's no requirement to have a 504 plan first. Adam, just so you know, I got a question or a comment in the question and answer that's chat is disabled. So if that's something you can fix on your end for the chat. All right, moving along. As far as the Individuals with Disabilities Education Improvement Act, or the IDEA, which again is we're talking about IEPs, there is an identification. We're gonna go through this, but generally, here's what we're gonna cover. We're gonna cover the identification, how students become identified, what's the process, what as a parent can you do to help that process along. We're gonna talk about, there's a lot of acronyms in our law. One of them is FAPE, and that stands for Free Appropriate Public Education. That's what you're entitled to under your IEP, and we'll talk a little bit about what that means. We'll also talk about the least restrictive environment. Sometimes that's referred to as the LRE. We're also going to cover procedural safeguards. So those are the protections parents have under the IDEA. And we'll talk about, so let's talk real quick about some generalities. FAPE, which is a Free Appropriate Public Education, is provided through what's called the IEP, or the Individualized Education Program. And that IEP is supposed to provide the student educational benefit. We'll talk about all of these. It includes necessary related services, and again, related services can be occupational therapy, speech and language, social work, physical therapy, vision therapy, nursing services. All of those are examples of related services. And in Illinois, when a student turns 14 and a half, they're also entitled to transition services. Those are services designed to assist a student going from high school to post-secondary life or life after school. And that planning starts at age 14 and a half. When we talk about FAPE, we're talking about, well, before we get to this slide, let me stay here. When we talk about FAPE, we're talking about free. So free means that it's provided at public expense. Now, sometimes students with IEPs may get placed in a private school, but again, it's being paid for by the public school district. and without charge to the parent. In addition, appropriateness is the other part of it. So free is easy to define. Appropriate is not so easy to define. And so courts have talked about children needing to receive meaningful educational benefit. And there's been a lot of discussion and fighting over what that means. What does meaningful educational benefit mean? And we're going to talk about a fairly recent Supreme Court case that'll help us with that. When you turn 3 and all the way until you turn 22, you are entitled to a free appropriate public education. So when it comes to school-based services, children are eligible as early as 3, all the way to 21. And there was a recent change in the law, which we'll talk about, that said if a student turns 22 in the middle of the school year, they're allowed to finish the school year up. So that's why I said, it includes 22 now. The first case that came up from the Supreme Court talking about what you get, what is educational benefit, was the Rowley case. And the Rowley case and some of the other cases, let's talk just a little bit about the Rowley case. This was the Supreme Court case. Amy Rowley was the student. She was a kindergarten student, and she was a smart student, and she had a hearing impairment. And her parents wanted a language translator, someone who would sign in the classroom for Amy. However, and the district tried that. They tried the language interpreter, the sign language interpreter, and they didn't think that it was helping, so they took it away. And Amy's parents disagreed with that, felt that if she was going to become the best student possible, she really needed that service. The court actually ruled in favor of the school district in this case, because when Amy did not have the sign language interpreter, she was still, not only was she passing all of her classes, but she was doing better than most of the other students in the class. So, when you look at the Rowley case, we know that this is not this law doesn't provide the maximum educational benefit, but it's certainly not the bare minimum. There was a case that talked about, you're entitled to a serviceable Chevy as opposed to a Cadillac of an education. And that's kind of what we lived with for many years. I mean, the Rowley case was in 1982, and there really wasn't any additional cases to kind of talk about what educational benefit meant. And some cases, some courtrooms were saying, oh, it's just a little bit. And others were saying, no, it's more than a little bit. And so there was a disagreement. And in 2017, the case Andrew F. eventually made it to the Supreme Court. And this was a case that Andrew F. was a child with autism, and he was receiving IEPs, and essentially the same IEP over and over again, kindergarten, first, second grade. There wasn't a whole lot of change in Andrew's academic and functional progress. He wasn't making great progress. And by fourth grade, the parents had enough, and they placed him in fifth grade in a specialized private school where he made significant progress. The parents sought reimbursement by filing a due process complaint, and the issue became, is he entitled to, more than what the district was giving him kindergarten through fourth grade? Is it more than de minimis? Well, what was interesting about this case is parents brought the case. It was an administrative hearing, and they lost. They appealed that into the federal court, and they lost. They appealed that into the federal appeal court, and they lost. And so it eventually made its way all the way up to the Supreme Court, who heard the case. Remember, parents have lost in 3 different levels. They've appealed this case twice. The Supreme Court got the case, and what was really interesting is they unanimously, so that's 9-0, they unanimously ruled in favor of the parent. And they said Andrew F. was not getting an educational benefit until he went to that private school. And so what Andrew F. tells us is that, the standard for educational benefit is more than just de minimis progress. I mean, and what it says is, if a student is not fully integrated into a regular classroom, his IEP should be appropriately ambitious in light of that student's circumstances. And if the student is fully integrated, then the IEP should be reasonably calculated to allow the child to achieve passing marks and advance from grade to grade. That was really what Rowley said. So what we now have this language of appropriately ambitious. There's no question that we now have, after Rowley in 2017, a higher standard of progress that's required under the IDEA, which also means that there's going to be a lot more scrutiny on how students are progressing on their goals, more scrutiny on how those goals are written, and more scrutiny on whether IEP teams really understand the students' strengths and weaknesses as identified in their evaluation. So, the story here is that from 2017 on, there's clearly more required under the IDEA than before. A couple other things I want to talk about. Disability or eligibility categories should never drive services. So if there's a student who's been diagnosed with autism, that doesn't mean that they get some set of services that all kids with autism get. Same thing with learning disabilities. If you have a learning disability, school districts can't just say, oh, well, here's our learning disability IEP. The I in IEP means individualized, which means that they have to craft an IEP specifically for the student before them, based on the student's needs and based on their strengths and their weaknesses. So districts should never be saying in an IEP that they provide this set of services, or say, well, we don't do that. They always have to consider a request for a particular service. They don't have to grant it, but they can't just dismiss it out of hand. There was a question from one of the folks about, do IEPs expire? That's a great question. So IEPs are annual, which means that on a yearly basis, the IEP team has to meet and discuss how the student progressed in their goals and what their IEP would look like for the following year. If a student is doing particularly well or has closed the gap and is no longer needing special education, I suppose the district could take away the IEP, but their parents have rights to challenge that decision. So IEPs are reviewed annually. In addition, the districts are required every 3 years to conduct an evaluation. So if a student is initially evaluated and it's determined that they are eligible for an IEP, that starts the clock. 3 years later, they are required to do another evaluation. So IEPs, let's say a parent removes their child from the public school and decides to go to a parochial school. If they don't continue to meet with the school district and get an offer, an IEP offer, then it would expire, right? If the parent removed the child from the public schools and didn't continue to engage with the school district. But generally they're reviewed annually. Hope that answers the question. I did mention this. This was a Public Act 102-172, which came out a couple of years ago. And basically that what it says is, as students are eligible for special education until the day before the student's 22nd birthday, unless his or her 22nd birthday occurs during the school year, in which case he or she is eligible for services through the end of the school year. So basically, students who turn 22 can finish up the school year, and that wasn't always the case. So we just talked about certain principles, guiding principles for the IDEA. We talked about a recent case in 2017 that kind of raised the standard. Let's talk about the nuts and bolts on how you get services. If you think your child needs an IEP or your child has an IEP and you need to make changes, let's talk about how that works. All right, so when we're talking about the application of special education law, the first thing to note is that school districts actually have an affirmative duty, a responsibility to identify students who might need support. That means that if a student is not doing well, struggling with grades, struggling with social emotional issues, they can't wait for a parent to ask for an evaluation. They're supposed to identify these students and raise the issue themselves. However, a referral for an initial case study evaluation can and often does come from a parent. So it can come from a parent, it could come from an employee of a school district, and it's for any child suspected of having a disability. Now, typically, referrals are made by school districts, parents, or sometimes a private provider who has knowledge of the child. There is an idea called RTI, which is another acronym. It means response to intervention. So districts have a process where they are allowed to provide interventions to hopefully catch kids up. And if you can catch a kid up and it's successful, then they likely don't need an IEP. But RTI, and if a child's getting a tiered intervention, that doesn't delay the district's need to respond to a parent's request for a case study. So if a parent does want a case study evaluation, they should put it in writing. And even if their child's in RTI, the district still has to respond and say yes or no. What's the timeframes associated with that? A district has 14 school days to respond to a parent's request, to parents requesting a case study evaluation. During those 14 days, the school district can use screening data. They can conduct preliminary procedures, talking to teachers, talking to classroom teachers, talking to specials teachers to see, what their input is and to assist them in making that determination. If a school district declines to do a case study evaluation, they have to put that in writing and they have to give you notice of why they are denying it. They have to provide you with an explanation. There's a question, if you don't agree with their decision to conduct a case study evaluation, can you appeal the decision? And the answer to that is yes. Parents can request a hearing. It's called a due process hearing or a due process complaint to contest the district's refusal to conduct a case study evaluation. So there is an appeal process. The bar for a case study evaluation is relatively low. I would say if there are concerns within the school setting and parents have a private provider that's also concerned, that's probably enough to do a case study evaluation. However, if they deny it, you can appeal that, you can file a complaint, and then you can ask an impartial hearing officer to order the school district to do a case study evaluation. So there is an appeal process for that. If a district does agree to a case study evaluation, then the next step is that the parents have to consent for that evaluation. And that typically happens at what's called a domain meeting. A domain meeting is a meeting with usually parents and the school team. And the school goes over a proposed evaluation. It's called a domain meeting because there are 8 domains that schools look at that are areas for evaluation. And I'll just give you a couple of them. So cognitive testing. So looking at a student's cognitive profile. Is that an area that schools can test for? Yes. Academic performance. That's another area. So reading, writing, math, how are they doing in those compared to their peers? That's a domain area. Functional. So how is the student, functioning within the school? Social emotional. How are they doing from a social emotional perspective? There's also medical, vision, hearing, communications, so speech. All of those are different areas, and the purpose of the domain meeting is for the district to explain what they're proposing to do and explain it so that any consent that's given is informed consent, right? You understand what you're signing consent. And then the school district has 60 school days to conduct the evaluation. And that's quite a bit of time. So just know that the 60 school days doesn't start on the date the district agrees to do a case study. It starts the day the district, I'm sorry, the day the parent signed consent. All right. Is a denial of a case study evaluation justified? Here are the factors that I look at and school districts should be looking at to determine whether or not a case study evaluation should occur. You want to look at grades, right? So if a student's grades suddenly dip or they're unable to successfully perform, that could be evidence of a disability. We're looking at behavior. How are they behaving? And when I say behavior, I don't just mean externalizing behavior where a student is, verbally aggressive, throwing something, physically aggressive, but what about behavior like putting your head on the table, right? Like that is a behavior that could cause a student to potentially have a disability. Peer relationships. Are they able to form successful relationships with peers and, quite frankly, adults? Are they able to work in groups? We look at emotional well-being. How are they? Are they anxious in the school setting? Are they going to the nurse a lot, right? To maybe escape or have stomach aches, headaches, are those things? How are they attending school? Is that an issue? We also look at, how they're performing at home. A lot of kids could keep it together at school, and then they kind of fall apart at home where they're more comfortable. Sometimes court involvement could be something to look at. Drug and alcohol issues. A lot of kids, even older, especially older kids, sometimes self-medicate when they're having social emotional issues. And then hospitalizations. Are there times where that student is unable to be safe and they need to be in either an inpatient hospitalization or a partial hospitalization? There was a case that came out fairly recently, 2022, only a couple years, less than 2 years ago, that I think gives us some guidance on when to do a case study evaluation. And this was, even though this is a case that came out of California, oftentimes we use cases from other jurisdictions to help guide us because there just aren't enough cases out of Illinois or any one state. So a district, basically this case, the judge said that a district can't wait till it has a reasonable certainty of eligibility. A child find obligation begins when it believes a student might have a disability. And I think that's really important to note. At 10th grade students, academic decline, a private diagnosis of anxiety and depression were enough to trigger a school district's child find violation. It's not enough for a district to provide a student with a 504 plan. Again, we talked about that. Adopting a 504 plan doesn't satisfy a district's obligation to conduct a special education assessment under the IDEA, which is a different law. All right. Moving along. Got a couple questions in the chat. What defines disabled under an IEP? That's a great question. I thought I had a slide on this, but there are 13 disability categories that include autism, specific learning disability, emotional disability, multiple needs, cognitive impairment, speech and language impairment. So there, physical impairment. So there are a number of disabilities, 13 in total, that you can be eligible for under the IDEA. Evaluations have to be comprehensive, non-discriminatory, use a variety of testing methods. One thing that I've been mentioning more recently, because a lot of kids are in crisis right now, kids don't necessarily decline on a nice, easy, slow trajectory. Sometimes kids, they're really have a traumatic event or just are declining really, really quickly. There is a concept of a diagnostic placement where a child could actually go into a special education classroom in a school and be part of getting some support even before they're eligible. It's called the diagnostic placement, and that's part of the evaluation, is that they're actually receiving services and getting data in the new classroom. So that's something to think about if there's a real change in a child's functioning. If the parents disagree with the results of an evaluation, they do have a right under the IDEA to request what's called an independent educational evaluation. The school must provide the parents, upon request, information about where this independent evaluation can be attained. And the criteria of the provider is the same that when the school that the school uses. A parent doesn't have to even use somebody on a school's list to perform the evaluation. If it just has to be a qualified examiner. If the district disagrees and says, nope, our evaluation is solid, we're not going to pay for this independent evaluation, they then actually have to file their own complaint and ask a hearing officer to validate that they did an appropriate evaluation. So there's oversight if they say no. There's a question about the anxiety and social emotional disability triggering a child find responsibility. And that question is asking that, given that there's some data showing 1 in 6 teens are suffering from anxiety or depression, how does the school district manage the load of evaluations when they're typically looking at, one school psychologist to 500 kids? That's a great question. So while even if the case of, well, let me say this. A lot of kids have anxiety and depression and do and get, outside treatment, and it doesn't impact them from a school perspective. So I would say that there does need to be some sort of impact on school functioning in order to trigger the need for a case study evaluation. In that case that was talking about the private anxiety diagnosis, there was also declining grades, and I think that would really shift the number of evaluations that a school needs to do to be much more reasonable. I will tell you, I don't know that we'll get to some of the slides towards the end, but a lack of resources is not an excuse. So schools are very much also impacted by by the pandemic and coming out of the pandemic, and so there are a lot of openings for speech and language pathologists, a lot of opening for special education teachers, and what we're finding from the case law is that's just not an excuse. And I will tell you that I've had districts tell some of my clients, look, we don't have a speech language pathologist. We're keeping track, and we know we're going to owe you speech language services, but if you want to use somebody in the community, we'll pay for it, right? So they have to get creative and figure out a way. And I would say the same thing would be if there was a number of evaluations that needed to happen. They have to find out how to get it done. There's also a question about whether an IEP would hurt college admissions process. I've actually never heard of that. In fact, students, so IEPs don't carry over to college, but Section 504 does. And so typically having an IEP is a great document that your student can take to the college disability office and ask for accommodations through Section 504. So I think actually it potentially could help when it comes to getting to college. And really there's no notation in a transcript that a student has an IEP. I mean, there's no asterisk next to a student's grade if they had an IEP. So I've had kids talk in some of their essays about, you know, the challenges that they've overcome and the disabilities they've overcome, and actually that could be quite powerful. So I would say no, having an IEP does not hurt college admissions process. All right. Another question: how would a parent advocate for a child to be evaluated for an IEP if the student or the child's been expelled from school and is being denied public school access? Great question. If a student is expelled, and there's a suspected disability, you still have a right to ask for that case study evaluation. And while you may be expelled from the school, if you're found eligible, there may be a special education services that still need to be provided in a different school, which potentially could be a therapeutic school. All right, once you, let's say the district agrees to do the evaluation, what happens next? There is a meeting to talk about the evaluation. It's a conference to determine eligibility. And if the child is determined to be eligible, an IEP has to be written for that child within 30 days of the eligibility determination. And I will tell you from a practical standpoint, I would say that in probably 90% of my cases, you have an eligibility meeting and then you immediately roll into an IEP meeting. Everybody's there. We've decided eligibility. Now let's plan for the IEP. As part of that, there is a placement decision that's made. Schools must wait 10 days, and this is for any IEP, before the placement and services can actually be implemented. So on an initial eligibility, parents have to consent to eligibility, number one, and number two, schools have to wait 10 days before the IEP can go into effect. The purpose of that is so parents can consider the offer. If they want to file an objection, like a complaint, they have time to do that. Parents also have the ability to waive the 10 days and get their child services immediately. And I would say that happens the overwhelming majority amount of time because most of the cases are collaborative. There's no conflict. Everybody's on the same page. And then the parents agree and they waive 10 days and the child gets those IEP services right away. It's important to know that IEP team members, you need a regular education teacher if the student is going to be in or will be in special education. I'm sorry, regular education. You need at least one special education teacher or provider. You need an administrative representative, somebody who can allocate resources. Parents, okay, and by parents, I mean guardians as well. If there's an evaluation, there needs to be someone who is there to interpret the evaluation. And then any other individual requested by the school district or parents who have knowledge or special expertise regarding the student. The student may be an IEP team member. That is a decision for parents to make. Certainly as students get older, there is a benefit to having students be part of the process, but it is the discretion of the parent until that student turns 18. And I would say, when we talk about other people who can come, I mean, I often tell parents who, if they want to bring a note taker, bring a friend, have that friend take notes because it's a lot to kind of hear everything, also take notes. I think that's a really good strategy so that you can be a fully informed participant and fully participate in your child's meetings. The IEP gets reduced to writing. It's developed by the student's IEP team, which you are part of that team, and it outlines a plan of service. We're going to talk a little bit about that. I already mentioned that the IEP has to be individualized. That means personally tailored to meet the students, the needs of the student. And you can't do that without understanding the comprehensive case study evaluation. The case study evaluation gives you the information about where the deficit areas are, what types of goals need to be written, and then what kind of related services are needed. It's really important when you're looking at goals to understand that a goal has to have a present level of academic achievement and functional performance. Basically, you need baseline data. You need a starting point. So if there's a reading goal and that goal is in reading fluency, you need to have some statement about where your child can read, how many words per minute can they read today, or the day this IEP is written. And then we need a measurable annual goal, which includes short-term objectives. So in the area of fluency, that could be, the goal could be we want to increase the students' words per minute by 80 words in 1 year. And then every quarter, we're gonna add 20 words per minute. I'm just making that up, but that would be an example of a measurable goal with baseline data. If you don't understand the goal or the objective, you should ask questions, because if you don't understand it, the concern would be, would a teacher picking up the IEP understand it? So again, really important that these are data-driven documents, because IEPs have accountability, and we want accountability, right? If our kids are not meeting their goals, we want to have a conversation about that. We want to know, how are they going to intensify the service? How are they going to change the way that they're doing services? Are they going to pull a different program? And if they are doing really well, maybe we want to have a meeting in the middle to really increase the goals. Let's make them even more ambitious, because we're getting a lot of progress. So it's really, really important that the goals are written in a way that they're data-driven. We talked about both direct and indirect related services. So that what that means is, it means that you can have a social worker involved and meet directly with the student, either in the general education setting or pulled out of the general education setting. You can also have the social worker consulting with the teacher. You can have an occupational therapist consulting with the teacher, maybe modifying how we do handwriting and how we do written assignments. So it could be indirect or direct. And the amount and types of services, again, there shouldn't be cookie cutter. They're based on individual students' needs. Before I go on, there's a question. If a student fails to provide IEP services and ESY, will the district reimburse families for services provided outside of the school to compensate? Potentially. I mean, if the school fails to provide IEP services, first of all, you should be getting a written notice of that. And you should get there should be compensation. Sometimes districts will do that within the school day. Other times they will do it outside of the school day. Sometimes they'll do it over the summer. So there's a lot of ways to deliver compensatory education. One thing to note is that related service minutes are documented in related service logs, and you have a right to those logs on an annual basis. So you have a right to look at the logs, make sure you're getting the minutes that your child is entitled to, and if you're not, to make that request for compensatory education. There's also a question, who decides the goals? Do parents get involved? The answer for that is absolutely yes. In fact, there's been another fairly recent change. I think we're probably going on 2 or 3 years now. All of the documents that are going to be considered at an IEP meeting, including draft goals, have to be provided to parents 3 school days before the IEP. And that's really important, because if you are working with an outside expert, whether that's a tutor, whether that's a psychologist, whether that's a social worker, you can actually take those goals to your providers and get their input on it. So parents are absolutely involved, not only in being able to take those goals and get input from providers, but at the meeting, you absolutely have a right to ask for changes to the goals. You have a right to ask for amendments to say, hey, look, I don't see baseline data on this. I want baseline data, and they should agree to that because it's required under the law. Okay, so the IEP also has a statement of individual accommodations that's in the classroom and for tests, like statewide tests or district-wide tests. And so, accommodations and modifications can be as creative as you need to be to address specific needs. It could be everything from movement breaks to a sensory diet, to communication logs with parents on a weekly basis. All of those could be accommodations and modifications. And then we talked about transition services beginning at 14 and a half years of age. All right, and then extended school year. That is called ESY. It's summer school. It's basically special education, summer school, and students are typically entitled to summer school, special education summer school, when there's evidence of regression. That's one basis. So, for example, if a student comes back after spring break or winter break, and there's some regression in their skills, like things that they had learned, they had forgotten, that is a really good indicator that they should get ESY. If a student is significantly behind their peers and the gap is significantly wide, that could be another reason to have extended school year or ESY. All right, I'm going to jump around a little bit and move to related services because I'm just looking at the time. This is a list. It's not an all-inclusive list, but just to give you an idea of what related services could be. We talked about a lot of these, but again, the list is pretty varied. Once you get to the end of the IEP meeting, there's a discussion about placement. Where is the child going to be placed to receive their goals, their related services? And there is a continuum of services. So if we look at the least restrictive continuum, we start with the regular classroom. Regular classroom, general education, and folks actually push into that classroom to support the student, and they can push in during a particular period. If there's a disability in math, that might be a time to push in, or they could push in during writing if they're an occupational therapist looking on writing. That's the least restrictive. Kids do get pulled out for resource room. That's for particular periods. So there could be a need to do pre-teaching or reteaching, or maybe teaching at a different pace in a particular subject like reading. That could happen in the resource room. There are also separate classrooms. These are we're still in our neighborhood school, but separate classrooms where students can, a classroom could be geared specifically for students who have social emotional deficits. So there might be a social worker in the classroom where, most, if not all, neighborhood schools, they don't have social workers in their classroom, right? There's also specialized classrooms for students with communication disorders or autism. There's students who need a modified curriculum. There could be a separate classroom for those kids. Moving down the continuum, you might have heard of a special education cooperative. That is a special education school district that is generally deals with a geographical area. So up here in Lake County, we have CEDAL, which is Special Education District of Lake County. They have their own separate day school. I think that's in Gages Lake. They also have special classrooms that they run in some member districts. So even if you go to District 50, for example, if District 46, Grays Lake, if they have a CEDAL classroom in one of their buildings, a student can actually attend that building instead. And then we move to the private sector. So there are private therapeutic day schools. Again, there are a number of them in Lake County, number of them in the Chicagoland area. And these schools tend to specialize in a particular type of disability. So there are therapeutic day schools for kids with behavioral, externalizing behaviors. There are therapeutic day schools for kids with depression and anxiety, more internalizing behaviors, kids who had been diagnosed with autism, kids who have been diagnosed with specific learning disabilities, and the whole school is working with that one type of population. And then we have residential schools. So some students need 24/7 care. Maybe they can't keep themselves safe, or they need a significant amount of support. And that's probably the most restrictive, other than homebound or hospital placement. And when we're talking about free and free appropriate public education, remember, if a student's placed in a residential program by their school district, it's getting paid for by their school district, right? It's not parents paying. And also, if they have to go to a different school, transportation is included and paid for by the school district. All right. I'm going to talk a little bit about progress. And so when we look at progress, we want to start with the case study evaluation and see if the student's making progress on their goals. Are their goals measurable, and are they making progress? Progress updates are given at the same time that the general education students receive report cards. So if you're on a trimester basis, typically every trimester. If you're on a quarterly basis, typically every quarter. In addition, IEP goals are reviewed annually. And like I said, there's also a 3-year a reevaluation. So those are all times when you're looking at progress. Quarterly or triannual, or every trimester, in addition to annually, and then again at the reevaluation. If you ever have a question, if you ever suspect that you're not quite sure what's going on in the school, if you're working with a therapist or you're working with a provider like an ABA provider, you do have a right to observe or have your expert observe in the school. So that's always a good option to get a better understanding of progress if you're not sure. When we look at least restrictive environment, we look at a number of factors. Can the students' needs be met in the homeschool setting? Will they get a satisfactory education? Are they benefiting from access to non-disabled peers? And what level of related services do students need? One of the people attending mentioned that there's, one school psychologist for every 500 kids, and that's probably true in a high school setting. So if a student needs therapeutic support on a daily basis, they're probably not going to be appropriate for a high school. High schools just can't provide that level of support. I'm going to skip through some of these cases because we only have a little bit of time, but you will have the PowerPoint presentation. So you can certainly read those. There's a slide on that 3 days prior getting access to records, so you'll have that as well. As far as communication, remember that you can call an IEP meeting at any time. So even though we talk about IEP meetings needing to be reviewed annually, if there's a change in your students' functioning, or there's a concern that you have, whether that is a bullying concern, or you feel like your student is struggling with social interactions or academics, you can ask for an IEP meeting to address those. And the district, can say no, but I would say that rarely happens. I mean, if there's a valid concern, you should be having an IEP. And quite frankly, if the district has concerns, if the district is seeing a change in functioning one way or the other, they should be calling an IEP meeting and inviting you to talk about it. So, if things are going rocky, it's not at all uncommon to have 3 or 4 IEP meetings a year. When you do have IEP meetings, I think it's really important to keep the focus on the student and to be careful what you say in email. I always say, don't write anything in an email that you wouldn't want on the front page of the Chicago Tribune, right? Keep it professional. There's a lot of emotion in these cases, but keep it professional.
Neal?
Yes.
I have a question here that I've seen kind of pop up in a few other questions, and maybe you answered it, but I didn't hear it. Can guardians request an IEP or case study if the student is expelled from school and cannot attend any school in the state?
Yes, yes, absolutely they can. So if you're expelled from school and you believe that your child is eligible for special ed services, you still can ask for that case study evaluation. Now, I will tell you, it's not going to get you back into the school or overturn the expulsion, but it would provide, the district would be required, if found eligible, to provide special education services. And many of the programs where expelled students go to don't have those special education services. So it could result in a change from like a safe school, like one of these ROE, Regional Office of Education Safety schools, to a therapeutic day school. So you can still request a case study evaluation, even if you're expelled. And if you are found eligible, the expulsion doesn't stop the district from providing services. In addition, with communication, it's really important when you do talk to folks at the school that you write down both the date of the call, who you talk to, and then the conversation. And I always recommend, if the school prefers to talk, on the phone, that you follow up with an email and say, hey, look, thanks for talking to me. I appreciate you sharing. I shared with you my concern about the drop in grades. It's my understanding that the case manager is going to talk to all of my son's teachers, and that you're going to get back to me in a week, right? Like, document what's actually said and what they promise to do, if they do promise to do something. And that way you have those written notes, which can be very, very helpful if things do end up becoming litigious. You can be an advocate and be kind. I will tell you that when I do get involved in cases where there's a disagreement between the school and the parent, and the parents have a very good relationship with the school district. Those cases tend to be easier. And there is a hierarchy in the school district. So if you are, I mean, I'm going to say some generalities, and maybe there's a building principal out there that would take issue with this, but I've always found that unless the building principal has a special education background, they're often not the best person to go to with your concerns. So if you go to your case manager and your concerns are not being heard, or you feel you're not being heard, or things aren't changing, rather than go to the building principal, I say go to the special education director at the district office. That could be a special education director, it could be assistant superintendent of special education, to talk about your concerns. We're up against the clock here. Do you need to bring an attorney? There's a slide here that talks about how attorney involvement could be how you can work with an attorney. Sometimes we work with clients behind the scenes, so we're just providing consulting. But this just gives you some examples. We did talk about due process complaints. If you have any disagreement about evaluation, identification, placement services, or any provision of that free appropriate public education regarding your child, you can file a complaint. If you can't, if going to the special education director is not working, you can file a complaint. You can go back generally 2 years, and raise claims to 2 years prior to the date of the complaint. Last thing I want to leave you with is some just really quick tips. When you are going to these meetings, when you're writing an email, when you're interacting with your special education director, make sure you do your homework. So whether that means talking to your providers and getting some clinical information that can be helpful to support your position, stay focused and brief and realistic. I mean, a 3-page email is not going to be effective in getting your child the help they need. They won't read it. They won't be able to follow it. Stay focused, brief. Use experts in the community if you've got them. Bring them to an IEP meeting. And then finally, don't be intimidated. I mean, you as parents, your children, and as guardians, your children best. And then also, we talked about it, document. So those are the tips I'm going to leave you with. It's 7:31. I'm only 1 minute over. And I think I got through most of the questions. Oh, what can I answer? Can I ask one more answer one more question?
Sure, absolutely.
Okay, because this is really important. Can a child be denied an IEP just because they have good grades? The answer is no. And this is a very, very common mistake. I see it more, quite frankly, with some of the larger urban schools. But there are kids who are so bright, but they have absolutely no ability to work in groups. They can't interact with their peers. They have lots of anxiety. Just because you're smart and have good grades doesn't mean you wouldn't qualify for an IEP. There's more to it.
Okay, I want to, first of all, I want to thank Neal for once again providing an incredibly informative presentation. I have posted the links for the PowerPoint, so you can go to our website and download that. Since we are recording this, I will do what I can to get out a link. But just so you know, for your own information, if you go to our website to the youth services section at www.warrentownship.net, there is a page under youth services that has previous workshops, and it'll eventually be posted there. It might take a few days. With that said, Neal, I again can't thank you enough for presenting. Hopefully we will see you next March, and get these wonderful updates again on all the laws and the changes. So with that, I'd like to wish everybody a wonderful evening, and we look forward to seeing you at future workshops. Take care and have a good night.
Thanks, everyone.